Good day, Crime Talk aficionados. This is Scott Reisch of Crime Talk, and we have a lot on the docket today. First, dodgeball equals assault, or is it simply a case of TMM? Next up on the docket, Mr. Dulos' attorney has the discovery, and what's he saying? Number 3, Mr. Epstein's attorneys are worried he may not make it to trial. Number 4 on the docket, the Rosenbaum jurors need to start all over again. A 79-year-old gets 10 days in jail for her cats, and the most prolific serial killer you probably have never heard of. Let's talk about it. Good day, Crime Talk aficionados. This is Scott Reisch of Crime Talk. Thank you for watching our channel. If you like it, please subscribe. If you would like to receive notifications, hit that little bell. And please, if you like the video, hit that thumbs up and leave us a comment. So today, let's talk about TMM. That is a serious condition called too much mommy. All right? This is a condition that pops up and develops particularly in the criminal defense area. It's like a disease where usually young men, young children cannot do anything for themselves, and that their mommies have to be there to protect them. It can become quite annoying and always a big tip-off when the client doesn't call, but his girlfriend or his mother does. It's called TMM, too much mommy. There's a case out of Canton, Michigan, where a 10-year-old boy has been charged with assault for allegedly throwing a ball at another student. Now, where the dispute differs is the mother of the alleged 10-year-old throwing the ball says that she was not aware of this situation and is simply outraged that somebody would do this. The principal states that this has been addressed before and that they believe that the 10-year-old dodgeball thrower, was targeting this other individual who has a condition. So normally 10 is about the age that most states can actually consider charging someone and holding them criminally responsible. However, I find it hard to believe that a 10-year-old could potentially form that intent. Now, I don't know these children from Adam, and I don't know if the principal's overreacting or if the mother truly believes that this condition, I'm assuming it exists, and that the child was at danger. It must have been, but this is the example of today's world. School resource officers charge it and let the courts sort it out. I could not imagine when I went to school anything like this ever being charged, but maybe I'm just getting old. Next matter on the docket today, Mr. Dulos' attorneys have received the discovery. They had filed a motion to dismiss, and the prosecution then produced the discovery, which consisted of some 25 discs in the case. Now, Mr. Dulos, Frodos Dulos, is charged with basically the tampering of evidence related to the disappearance of his wife. The police have alleged, and I believe they do believe, that Mr. Frodos Dulos did something to his wife and that she is possibly dead. It's very unlikely the mother of 5 would go off on this gone girl type of theory that the defense originally put out. However, there is no body. They have videotape, but no one has seen it yet other than the attorneys. And the reality of it is if they had a body and they knew how she died, under what circumstances, they would charge it if they can say, that is the gentleman, Mr. Frodos Dulos is the one that did it. They don't have that yet. I think it's going to be a tough case short of a confession. Number 3, Mr. Epstein's lawyers are worried that he may not make it all the way to trial. So Mr. Epstein, for those who are not familiar with him, he is charged in federal court in the Southern District of New York with child exploitation charges. He's previously been convicted many, many years ago in Florida for prostitution that come out of the exact same circumstances for which he's charged with in federal court. His bail was denied, and so he remains in custody. Shortly after he's denied release on bail, it's unclear or uncertain whether Mr. Epstein either attempted to commit suicide or was injured by another inmate. The other inmate, who is a former police officer charged with murder counts himself, apparently allegedly killed 4 people, denies any involvement of the injuries as it relates to Mr. Epstein. But of course, he may do that. And on the other hand, apparently the prisoner saying he actually helped save Mr. Epstein. So hopefully it'll be sorted out shortly. But Mr. Epstein's lawyers are now throwing out huge conspiratorial theories that powerful people want him killed and they don't want to have their secrets aired. Now, that may be the truth because Mr. Epstein knew a lot of people. A lot of people went to his ranch, went to his island, and flew on his Lolita Express, as it was known, his private airplanes. I'm sure there's lots of powerful people that don't want their name associated with him, let alone him saying what he may have seen. Now, on the other hand, he is charged with exploitation of children, and so he is not exactly high on the hierarchy in jail, let alone the Bureau of Prisons. So it's very likely that the prisoners will take care of him or make life unbearable for him. We'll see if Mr. Epstein makes it to trial. Next up on the docket, the jurors in the Rosenbaum murder trial have to begin their deliberations again. For those of you who do not know about the Rosenbaums, Jennifer and Joseph Rosenbaum are on trial for the murder for allegedly killing a 2-year-old foster child by the name of Layla Daniel, and I hope I pronounced her name correctly. Now, the Rosenbaum's defense team simply states that the young Layla choked on a piece of chicken and sustained the injuries that the prosecution is presenting as that of child abuse based upon the heroic efforts that the Rosenbaums took to save her, although she ultimately passed away. The prosecution is simply stating that injuries to Layla were sustained all over her body, and they were clearly older in origin, and that she was physically abused and is now deceased because of the maltreatment that she endured. So what happened here was the jury went off to deliberate. Apparently, and I can never, ever, ever understand this. And if I was the judge, my freaking head would explode, okay? I would lose my shit on this reporter. And a reporter apparently goes up to a juror and asks, how are the deliberations proceeding? And the juror then responds, we're not even close to being done, or words to that effect. The juror then self-reports to the judge that he had this contact, this interaction, even though he'd probably been admonished 100 times, don't talk about the case, don't discuss the case with anyone until you have your deliberations. And then once they begin their deliberations, that they can't speak to anyone about the case. They can't even speak to their jurors unless they're all assembled there. But this knucklehead juror comments, like, are you out of your freaking mind? Are you kidding me? He's been told this probably 50 times throughout this trial. If I was the judge, I would lose it on that reporter and potentially hold him contempt. Now, the juror probably got admonished and feels pretty bad, but ultimately doesn't get to deliberate. So he's now off the case. They bring in the alternate juror who doesn't start the deliberations unless there's a need for this. And this is why you have alternates, particularly in lengthy trials, because every now and then, somebody wants to do it their way. Somebody thinks they know it better. Somebody thinks they're going to get away with looking up the parties on the internet, Googling information about the case, or having contact with somebody and thinking no one's going to come and find it. The work, the hours, the preparation, the time that goes into a trial, and for a knucklehead move, like I said, I would have, if I was a judge, I would throw that reporter in jail on a contempt charge because I'm sure that reporter was in there and knew that he could not approach anyone. It's just common knowledge. And that juror, he's lucky. If I was the judge, I would have held him in contempt for violating the court's orders as well. Nothing more annoying. Now, the defense then moves for a mistrial. Of course, the judge denies it, brings in the alternate, and they begin the deliberations. We'll see. We'll see what happens. But now all of a sudden it's a great issue for the defense that a mistrial should have been granted. So in a case that was relatively clean, here you have now a situation that's been created that didn't need to exist. And who knows? It could be an issue and get to do it all over again. Why jurors refuse to follow the court's orders is beyond me. It's flabbergasting me, but it happens. I wouldn't say all the time. I've probably had it happen 10, 15 times in my career. Jurors report, they go back, they look something up. We've had cases here in Colorado, death penalty cases where jurors bring the Bible in deliberations. Can't do that. You can't bring anything in. Jurors can only consider the evidence that's been admitted, the testimony that they've heard come from the witness stand, and that's assuming the judge told them not to strike that particular evidence. That's it. They don't get to have any extrinsic contact with anyone, and it's my pet peeve in life that jurors think they can get away with it. All right, so the next matter on the docket is a case of a 79-year-old woman by the name of Nancy Segula. And she lives in Ohio. And apparently she gets to spend 10 days in the Cuyahoga County Jail. And you may say, what could be the heinous crime that a 79-year-old woman needs to go to jail in Garfield Heights, where Miss Segula lives? You cannot feed stray cats, and that's illegal. I get it. You can't have stray cats. They come from everywhere. They breed like cats. There you go. You can't feed them. They just keep coming around. But apparently, Miss Segula has done this before. Apparently, she's been warned repeatedly not to feed the cats. Well, she fed the cats. Now she's going to jail for 10 days. Perhaps a fine, so she couldn't afford to feed the cats. But 10 days in jail for feeding the cats, I'm not sure that's necessarily appropriate, but maybe the judge felt that worthy. Perhaps when she pled guilty, she didn't have any remorse or basically said, I'll do it again. So the judge has to say we have to make this punishment something that's actually going to deter your future conduct and to deter others who may be aware of your conduct. So anyone going to Cuyahoga County, Ohio, will you be deterred to feed the cats? Okay. And I'm not a big cat guy, I'm not going to admit it. But I did have a guy once who didn't like his neighbor's cat, and he picked him up and drove him out to the middle of nowhere, and the cat never came home. He didn't even get 10 days for that. So 10 days seems a little excessive. So moving along. Let's talk about one of the most prolific serial killers that most people have never heard about. This is an individual by the name of Samuel Little, all right? Now, Mr. Little is 79 years old, and he is in failing health, and he is serving 3 consecutive life sentences in California for killing 3 women, and he has now confessed to dozens of murders across the United States. And he has provided, apparently, such detailed confessions that have proven to be true and have led authorities actually to the conclusion that there are some 60 killings that can be linked to Mr. Little across the country. And Mr. Little apparently has such a good memory that he actually draws portraits and paints in oils and pencil of the women that he has killed over the years. And Texas has brought him in for detailed statements. Ohio has brought him in for detailed statements that have resulted in additional charges being brought. It'll be very unlikely that he'll ever be transferred to any of these other jurisdictions to plead guilty. But here we have a man, some 79 years old, who basically wants to get this off his conscience and be done with it. Now, the Green River Killer, Gary Ridgway, was thought to be one of the most deadliest serial killers in the terms of number of guilty pleas, with 49 victims. But Mr. Little, he could be linked to some 60 killings from the early 70s until 2012, when he was ultimately arrested in California, living in a homeless shelter. Additionally, at his trials, not only did they have the DNA evidence, but other women that were able to come forward to testify as to their harrowing escapes from Mr. Little. So while Mr. Little was in custody, a Texas Ranger traveled to see him by the name of James Holland, and basically infirm, without any appellate options, and even though he had persisted in his innocence, he ultimately started giving confessions, beginning with a 1994 strangulation death in Odessa, Texas. And then a cascade of investigators began coming to see Mr. Little, and he kept providing more and more information. And so far, nothing has been proven false by what he has said. There's some discrepancies in dates, but for the most part, the information and the women that are missing has been accurate. Mr. Little looked for victims that had, for lack of a better term, been marginalized. He looked for sex workers, drug users that basically nobody would care about if they wound up missing. He would allegedly punch the victims and strangle them to death, and he would try to make it look as though it was a drug overdose or that they had perhaps died of natural causes. So the Samuel Little case, I think, is interesting in the fact that here we have an individual who, for lack of better terms, has been a drifter, homeless guy, most of his adult life, going around killing people. This is not unusual. I personally have handled cases where drifters go back and forth, and for whatever reason, DNA pops up, and they're ultimately charged. It's very, very common that this happens, and it's homeless people. It's women that are marginalized that they look for, just like Mr. Little, and they go about their way. And sometimes you know that the client has more to say, but he won't tell you. And even if he did tell you, you can't go tell anybody where anything is because it would be a violation of the attorney-client privilege. But for people to believe that these are isolated incidents, the Ted Bundys, the Samuel Littles, the Green River murderer, these are somehow isolated, I think they're more common than people think. Now, do I think, it's tens of thousands of people? No. But I think it's hundreds of people. And once these killers kind of have that first kill, so to speak, they need to relive that rush, and that's why they do it. Mr. Little, obviously not condoning what he's done or how or whatever reason he went about doing it. Obviously, killing like that is absolutely wrong and it's illegal, but at least, hopefully, some of these families will know what happened to their daughters, their sisters, and there'll be some closure, and hopefully the deceased will somehow know that, in fact, somebody was out there for them and they weren't forgotten, because the police were still looking and kept these cases open. That's it for Crime Talk today. Thank you very much for watching. Boy, I have talked so much, I think I need a drink from my Crime Talk mug. There'll be a link if you'd like to get a Crime Talk mug or any other Crime Talk merchandise. We appreciate it. You don't have to buy it, but if you like it, please do. Have a great day. Thanks for watching.